Good afternoon. We will call the case of People versus Scott. This is a mini oral argument on the application, 15 minutes per side. You have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that time if we don't use it up. You may begin whenever you're ready.
Thank you. Good afternoon, Your Honors. May it please the Court, Emil Sama on behalf of the people. I'm joined by my colleague, Jonathan Mysek, at table, and I would reserve 3 minutes for rebuttal at this time, Your Honor. And I will also at this time, Your Honor, waive my free fire zone and accept questions at any time from this Court. Thank you. At this point, Judge, regarding the first question regarding the automatic stay, I think the people have to concede on the plain language that there did appear to be an automatic stay in play pursuant to 7.305. The issue really came down to, and I don't want to spend a lot of time on this because I think the majority of the questions should come from 2 and 3, was while there was an automatic stay, there was a unique situation here that had to do with how the pleadings were filed. One, we did see a proof of service from Brother Counsel regarding that my file showed that it was filed on the 14th. However, after diligent search, the people have been unable to find any such filing to the people's case. We never received an electronic copy. We did not receive ours until the 17th or the 18th, and same with the court. I think that's important to understand that nobody had any idea this application was filed for days, which goes really into 2 and 3. So while there, by the plain language, was an automatic stay, I think that the devil is in the details of how that came out to play. But while that is there, while there was a stay, and while Washington does say that a court will lose subject matter jurisdiction, even though I'd like to agree with Mr. Boffman's amicus brief on this matter, Washington only held that subject matter jurisdiction was divested for those aspects of the case involved in the appeal. The only aspect of this case involved in the appeal was the 404B other acts evidence. It's not like it was a motion to quash where the whole challenge whether or not there was sufficient evidence to even go forward. It was just whether this evidence should have been admitted or not. Therefore, I do not believe subject matter jurisdiction was completely divested from the trial court. They still had subject matter jurisdiction over other aspects to conclude or to engage in that was not part of that appeal. And there was a plethora of case law, I know not from this court, but you see it from in other states as well, not
Counsel,
just from
good
the
afternoon. I just have a very quick question. And
yes,
this is just the one thing that I kind of think about as pertains to this case. If the court were to rule in your favor, could this lead to gamesmanship?
I would like to hope not. And you could always see it from both ways, because then the argument could be that this could also be a gamesmanship this way. Because, and you look at it this way, where it was filed by paper, it was sent to the court, to the prosecutor's address at an incorrect address, and yet trial counsel and the defendant were never told an application was filed. The people were never notified other than when we got the paper. So basically the defendant got a trial that now means he gets a second bite at the apple because no one told. So the gamesmanship can work both ways. You can work the gamesmanship by not telling anybody, not telling the court, and not having it my filed, only having it paper filed. A trial happens and said, oh wait, you shouldn't have done this.
That's my do you see what the concern is?
Yes.
I mean, is this something that could wind up leading to new trials all over the place?
Absolutely, and I think that's why when you have procedural rules, for fairness, it cannot be so inflexible as to paralyze all the courts. Because if that were the case for procedural rules, then I think it would lead to absurd results, especially here. Right? When you look at the result here, we're going to have exactly the same trial. The other acts evidence is going to be admitted. The DNA evidence is going to be admitted. The only difference is a different panel of 12 people in that jury box. No other practical difference whatsoever. And that, I think, is important, especially when you're looking at fairness, flexibility, and the difference between subject matter jurisdiction and procedural rules. And that's what I would say we have here. We did not divest the trial court of total subject matter jurisdiction.
So do we need to do a harmless error analysis?
I'm sorry?
So do we need to do a harmless error analysis if we say the trial court shouldn't have moved forward because they didn't have subject matter jurisdiction over this one specific issue? Do we do a harmless error analysis?
I think you could. I think it could still be done. For example, there's a couple ways a harmless error analysis could have been. So for example, let's assume the court was going to grant, it denied application, so therefore the error was harmless because this court denied the application originally, and because nobody raised the issue in the trial court at the time that there was an application pending. But let's assume for a moment that this court was going to grant the application. There would be a harmless error analysis inherent in that decision. because the argument would be the 404B evidence could have been improperly admitted, and therefore the question then becomes with, if the 404B evidence was improperly admitted, was it harmless to admit it? Which is what we deal with all the time when you have other acts evidence.
No, I'm
So-
sorry, let's take a step back.
Sure.
So, even if our court ends up denying that interlocutory appeal, okay? I'm saying, if the trial court didn't have subject matter jurisdiction while it was working its way through, let's say that's the position that we take.
Oh,
That's
that
how
it did not have, I'm
that's,
sorry.
That's how we apply Washington
Okay.
to interlocutory appeals. To me, what took place was, it could be void, or you could do a harmless error analysis and say, if it's gonna be the same trial anyway, everything would have been the same because everything was gonna come in, you do harmless error analysis. Now, the example that you gave me, to me, I don't know how you do a harmless error analysis there. Because if we grant or do a MOA in that interlocutory appeal on whether or not that other X evidence comes in, and we say that it doesn't, or the Court of Appeals says that it doesn't, and the trial court moves forward, I mean, that's a problem.
That would be a problem in that situation.
So the harmless error analysis that I'm talking about is in the situation that we have here,
I
where you're
misunderstood.
saying it's basically the exact same trial, nothing else would have been excluded, it's just 12 different jurors.
Yeah, I misunderstood. I thought the question was, what if we don't divest subject matter jurisdiction? But yes, if you divest subject matter jurisdiction, I still believe, because it's a procedural rule that was applied here, I believe that you have to allow for the flexibility. I believe a harmless error would still apply here, and since nothing would be different, then I think that's a harmless error. Now, you're right, if something was different, if the court was going to handle it and say, no, this evidence should not have been admissible, then I think that's a different argument than yes, voiding or possibly reversing the conviction would apply here. But here, again, I have to reiterate, nothing would be different. We are basically putting the courts, the victim, the defendant, through a second identical trial on an issue that is really, that if we hold is so inflexible as to not allow for such flexibility, then basically we are putting form over substance. And every state in the United States, as you saw from Amjur 363, and I looked at a couple in the one there, and they talked about People v. Project v. State. There's a few others in that Amjur holding, and almost all of them follow some type of procedural rule similar to what this court held in Washington, where it's only the aspect that's on appeal. And in those cases where they're not part of the aspect on appeal, we don't simply reverse because there was a potential stay. And that's where the flexibility comes in. And I think it would be hard for Michigan to be really the only state to say we are so inflexible that once there's a stay, nothing happens.
Well, but, I mean, I think it's easier for me to see it in the context of a civil case, right, where there could be something's on appeal, but there are different claims going forward, or there are different, defendants or different parties going forward in that. But when the court rule says that when an issue about the admissibility of evidence is up on appeal, that the proceedings are stayed, like a criminal trial of a defendant with the disputed evidence, like what was stated, the trial with the evidence couldn't go forward. It did. But if that's the issue on appeal, is that really different? Like, it's not so easily separable, I don't think, in a criminal context, perhaps, which is why we have the rule that says proceedings are stayed once an evidentiary issue is up on appeal.
That's MCR 6.126, Your Honor. But at the time of this case, that was not in effect. It did not come in effect until 2020, actually adopted in 2020 and effective in 2021. This case was in 2016 and 2014, I believe, at one point. 2016 was the trial, or at least the opinion from the Court of Appeals. So this predated that rule. I think that rule today helps quelch the issues you have regarding flexibility and proper procedure to preserve those issues. But at the time when this trial happened, and at the time when these issues were raised, 6.126 did not exist. So I think 6.126, answers your concerns in that regard that we have moving forward. But looking back at when Scott was done, that did not exist, so I don't believe that the inflexibility that we're looking for, the flexibility that I'm asking you to find, is in contravention of those rules. At the time, there was no mandatory stay when there was an evidentiary issue at play. Now there is. Once you file something, the court shall, unless it finds the issue is frivolous. At the time, there was no such rule. We appealed the judge's rule denying that evidentiary issue. Court of Appeals reversed Judge Servito. An application was filed literally the day before the deadline, and nobody knew, not trial counsel, not the defendant. And that, I think, goes part of where the flexibility is. There's got to be some good faith here. Somebody should have raised. If we had known that we had gotten this thing, our first thing was stop the trial. We have an application. Defense counsel should have said, stop the trial. Especially defense counsel at trial, he's the one who requested appellate assistance for the defendant for purposes of filing a Supreme Court application. But at the day of trial, the day after they filed this by paper, no one was told that an application was filed, and they allowed the trial to go through without any objection. There's got to be some give and take, which I think where the fairness and flexibility needs to come in and put Michigan on the same path with other states that follow the same rule that Washington illustrated. It's only over those aspects of the appeal. I understand with criminal cases, it seems like it's all intertwined, but not always. And it's not like, like this was a motion. If this was a motion to quash, I'd be in a very different position. I would not be able to sit here logically to you and argue that there was no way we'd lose anything, because a motion to quash really does deal with the issues of whether there's sufficient evidence to even go to trial. So on that one, I would have to
concede. If we amend the court rules to require that notice be given, immediately, would that help cure your concern?
I believe so, yes. I think that would cure a lot of concerns with a lot of issues here. And you see a lot of the court rules changing to deal with all of our concerns. 6.126, I think, deals right off the bat with that concern. I wish it had in existence when Scott happened. Unfortunately, it did not. More clarity on the notice provisions could also be useful to help explain this, because when nobody knows an application's filed and the court sets a date for trial, defense counsel and defendant say we're ready for trial, prosecutor says we're ready for trial, and nobody sees an application until 4 days after the trial is already nearing its end. It's almost as though we're playing gamesmanship with both sides, and it's just, I don't think fairness allows for that, and the inflexibility that a court rule that says that would just be too much for our jurisprudence. At this time, I would like to reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. My name is Garrett Burton. I'm from the State Appellate Defender. I represent Mr. Scott. I'm joined today at council table by Ms. Marcus from my office. Your Honors, the prosecutor and I agree that the rule in Washington applies to interlocutory appeals. And what that means is the circuit court loses subject matter jurisdiction over those aspects of the case involved in the appeal. Applying that rule to Mr. Scott's case, it requires retrial. That's because his interlocutory appeal concerned the admissibility of evidence at trial. And without subject matter jurisdiction to conduct the trial, Mr. Scott's conviction is void, and he's entitled to another such proceeding. With that, I waive the free fire period.
What's the practice, if you are successful and the remedy you receive or your client receives is a new trial, isn't it an identical trial to what he had?
Yes, Your Honor. There's nothing, I agree with the prosecutor. It's going to be the same trial with 12 different jurors. I want to talk about why that's acceptable, though, in this context.
Okay.
The first is that that's the same exact remedy that this court ordered in Washington. This court understood that there was going to be what Justice Viviano called a pro forma resentencing. And despite that, this court recognized that subject matter jurisdiction is a necessary precondition for a trial court to have the authority to take someone's liberty away. And so when this circuit court acted in Mr. Scott's case, it didn't have that subject matter jurisdiction. It didn't have the one thing that we think is necessary to hold a trial, to pronounce someone guilty, and to throw them in prison. And so that ideal, that principle, predominates in a way that makes the remedy acceptable. What's more, Your Honor?
Help me out here. So your theory is, and I of course disagree with Washington. I think it was wrongly decided. I think it should be overruled. I think we should overrule it as soon as we can.
How do you really feel?
Yeah, what? You
I
agree?
said, how do you really feel?
Yes, unclear.
I think it's a disaster. This case shows why it's a disaster, because now we're having whole new trials. We're like the only court in the universe that just orders new trials for no reason. Let's have the same trial, same participants, same testimony, make the same decision, complete waste of time, a lot of cost, a lot of emotion, for no reason. Why would anybody do that? But anyways, let's leave that aside. I knew that this would happen because, as you said, it was pretty clear, easy to see when we decided Washington that giving rules jurisdictional effect that never were intended to have jurisdictional effect and never were drafted by anybody who thought they ever would be given jurisdictional effect, now all have jurisdictional effect. But my question for you is, and I think it's a complete misuse of the term subject matter jurisdiction, but maybe you can help me understand it better. So the circuit court has subject matter jurisdiction over felony cases, right?
Yes, Your Honor.
But then it loses that subject matter jurisdiction when a case is appealed, but only, what did you say, as to the issues that are encompassed in the appeal?
Yes, Your Honor.
So it partially loses subject matter jurisdiction?
Correct, Your Honor.
And so we should have lots and lots of cases to argue about what the contours of that is. That what we can expect in the next couple of decades to decide if this issue's on appeal, can the court do X, or if that issue's on appeal, can the court do Y? We're going to have to establish a whole new branch of this sort of partial subject matter jurisdiction loss doctrine that we're establishing today?
No, Your Honor, and that's the case for a couple of reasons. I'll start with what I think is the most persuasive, and that's that every federal circuit also follows this rule. They all endorse the Washington rule that when an interlocutory appeal is filed, this district court in federal court loses subject matter jurisdiction over those aspects of the case involved in the appeal. So this court has the benefit of that, what you call, Justice Viviano, that branch of jurisprudence.
Would they reverse and remand for a new trial without a harmless error assessment, the federal courts?
Yes, they did. If you look at the 11th Circuit, Your Honor, in that case, Tovar, we cited in my brief. That was a case where a suppression motion was pending. The district court went to trial. The defendant was acquitted. And then the circuit court said, wait a second, this motion was pending in front of us, this appeal. You got to undo the acquittal and retry her. And so the same trial was ordered again. And if you distill all of those federal circuit cases that we've cited in our briefing, you'll see that none of them have said that trial is permissible when an interlocutory appeal on the permissibility of evidence is pending before it. That's because it's inextricably bound up in the nature of the appeal. And that's a very administrable rule, Your Honor. Trial courts, no. It's, in fact, I think best practice that a trial court is going to stay the proceedings while an interlocutory appeal is pending. There's not the same risk of gamemanship that the prosecutor has identified. And if this court is concerned with it, this court can amend the court rules, like we've just talked about, to ensure that that doesn't happen.
Well, the gamemanship that I think causes, at least me pause, is the lack of notice.
Mm-hmm.
And I think that that's something that can and should be addressed. The prosecutor should have had notice that this was filed. As he indicated, the prosecutor's office would have said, stay the trial until we get an answer from the appellate courts on this. And the defense counsel could have done, and probably should have done, the same thing, instead of like, oh, we'll roll the dice here, see how we do, and if not, then we have the second argument once we hear back from the appellate courts. And so, I think that part of the gamesmanship, likely needs to be addressed. Is there another piece that Brother Counsel has raised that you think the gamesmanship isn't realistic?
Yes, Your Honor. So I'll address the gamesmanship in the context of this case, and then I'll talk about gamesmanship generally. So in this case, trial counsel first asked for appellate counsel, and second, they did move for a stay. 3 or 4 weeks before the application for leave to appeal was filed, trial counsel asked for a stay. And trial counsel, in asking for appellate counsel, was very candid with the court. He said he didn't understand how the court rules worked. He needed appellate counsel to assist him. And that is the source of confusion. The trial wasn't scheduled immediately the day after the deadline for the application for leave to appeal was due. The deadline and the day of trial were a coincidence. And the record sort of reveals to us that the trial counsel had no idea what was happening because he was so unfamiliar with those rules. He wasn't trying to game the system. He just didn't understand what was happening. So, and finally, with regard to this, Your Honor, the prosecutor did have notice. We presented to this court the proof of service that said it was filed the day before. It went to the email where it was supposed to go to. The prosecutor contends that some wires were crossed, but at the end of the day, we fulfilled our obligation to file that application for leave to appeal. Now, let me talk about gamesmanship generally. And again, there are enough procedures in place to ensure that gamesmanship isn't going to be an issue going forward. That's because there are court rules, like a motion for immediate consideration, that can allow us to dispense with this idea that someone is going to sandbag or delay a trial for as long as possible to make sure that we don't go forward with trial. If the prosecutor thinks that a defendant is abusing that process, they can file that motion for immediate consideration. Second, Your Honor, this court and the Court of Appeals dispense with these actions very quickly. You're good at your jobs, especially in the pre-stage where you're deciding whether or not to grant leave to appeal. That's decided relatively quickly. And so there's not a lot of opportunity for a case to drag on in a way that could impede the proceedings in the circuit court. And finally, there's enough incentives with a criminal defendant who's sitting in jail, languishing there, to want to move a case forward. That's why we have the speedy trial right, because we recognize that. And so all of those things in conjunction with each other are enough to guard against the possibility of gamesmanship. With that, Your Honor, I can address the third question, and that's whether there was any prejudice here. And I've already touched on this a lot with Justice Kavanaugh's question when I said that a new trial is necessary here. But that's in large part because of the Court of Appeals decision in Liscombe. And so that's a case where we're presented with a test about whether or not an error is one of subject matter jurisdiction or an error in the exercise of jurisdiction. And there, if you'll recall, the circuit court didn't formally have jurisdiction to try the defendant until this court returned a file to it. And the circuit court proceeded to trial without that file. And on appeal, the defendant said, hey, wait a second, there wasn't subject matter jurisdiction. The Court of Appeals says that's wrong. That was an error in the exercise of jurisdiction. And that's because there was no appellate action pending at the time. If there is that appellate action, either pending or available to a litigant, then subject matter jurisdiction is divested of the circuit court. But if what the circuit court is waiting on is some ministerial or custodial action, and in an instant like that, there's just an error in the exercise of jurisdiction. And here, there was that pending appellate action. This court was deciding on an application for leave to appeal. So for that reason, there was an error in subject matter jurisdiction. All of our jurisprudence in Michigan and throughout the United States has said that an error in subject matter jurisdiction renders everything that flows from that void like it didn't happen. And for that reason, Mr. Scott's trial is unacceptable. He's entitled to a new one. And with that, unless there are any other questions, I'll sit down.
I don't see any. Thank you very much.
Thank you.
I agree with Justice Viviano. While I have not asked for reversal, I'd love for this court to adopt probably the amicus, but if this court does keep Washington's subject matter jurisdiction definition, then yes, there will be cases defining what are the aspects of the appeal. Other cases throughout the states do that. But I think what the rule can be here is, if we're dealing with a case where total subject matter jurisdiction has not been divested, as it was here, because only the evidentiary issue was on appeal, then there is an argument for harmlessness here, and the harmless error doctrine should apply. And that's the rule that people are asking this court to apply in this matter. And if there are no further questions, I will be done.
Great. Thank you both. The case will be submitted.
Thank you.